Hello there, everyone. Thank you for joining us today as you're coming in the webinar room. I do need to do a little bit of legal housekeeping. I want to welcome you here again. My name is Marche. I'm the webinar director here at Advice Chaser. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars, such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we are thrilled to bring you today's educational event. A couple of housekeeping items as far as asking questions. Attendees are muted, but we do encourage you to ask questions using the chat box, and the presenter will answer those queries during or after the webinar presentation today as appropriate. If you ask a question in the chat box, go ahead and leave your phone number as well and your email address, and we're happy to reach out to you after today's event to make sure that your question gets addressed, even if we haven't had time to address it during today's presentation. Again, we want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. Well, I'd love to introduce you to our guests today. Our moderators are from the Tennessee Valley Group at Morgan Stanley, and here are a little bit about them. Alex Gilliam was born and raised in Farragut, Knoxville, Tennessee, and earned his bachelor's degree in finance with a collateral in marketing from the University of Tennessee. Alex started at Morgan Stanley in 2017 with the Tennessee Valley Group and is currently a financial advisor with a certified financial planner practitioner designation. Alex has a passion to understand the diverse needs of his firm's clients' lives and to develop the most appropriate investment strategy for their unique situation. Outside of work, Alex enjoys sports and serving in his church. And Alex, why don't you go ahead and come on the camera here and say hello to our folks here.
Yes. Hey guys, thank you so much for joining us, and we're excited to be here. Corey's going to go into a little bit more about our team. Thanks.
Very great. Well, Corey Wilson is a Senior Vice President of Wealth Management with the Tennessee Valley Group at Morgan Stanley, a graduate from East Tennessee State University with a Bachelor of Business Administration, focusing on finance. Corey also holds designations of Certified Financial Planner Practitioner and Certified Investment Management Analyst. Having worked in the industry since 2002, Corey offers clients a seasoned professional who is competent to assist you in making life-changing financial decisions. When not at work, Corey and his family enjoy spending time in service to his church and the community of Knoxville. And Corey, I know you were going to go ahead and say a few words, so I'll turn that time over to you.
Sure. Yeah, I just want to say thanks. If you're watching us live or if you're watching this via recording, we're happy you're here. We're happy to be here. Alex and I are just two of the members of the Tennessee Valley Group at Morgan Stanley. We have clients who live coast to coast and border to border, but we're all located right here in Knoxville, Tennessee. As part of our value proposition, what we actually bring to clients, most people realize that our advice begins with planning and portfolios and making sure our clients can accomplish their goals and dreams. But it really does go far beyond that, into covering risks and insurance and tax strategies and philanthropy and estate planning. And so my point is, we do believe in a holistic approach. And so when we were given the opportunity to moderate this event about estate planning for retirees, we were thrilled. We've actually had the good fortune of working with Lisa in her office on a number of specialized cases with our clients and general cases with our clients. Everything from just individuals who were just afraid to broach the topic because it all seemed too confusing and realized they didn't really have to be intimidated, two individuals who were maybe a blended family. In general, this topic is intimidating to a lot of people. And so I'm just thrilled to death that Lisa's here to walk us through some tips and tricks.
Well, Lisa, before we turn the time over to you, I do need to introduce you a little bit here. Lisa W. Gameltoft is a founding partner of the Kaiser Gameltoft and Brown PC. Lisa has over 30 years of legal experience in the areas of estate planning and probate. She received her BS in accounting from the University of Florida in 1986 and her law degree from the University of Florida in 1989. Prior to the formation of her firm, Lisa was associated with the law firms of Ann M. McKinney, PC in Knoxville, Tennessee, and Altman, Kreitzer, and Levitt, PC in Atlanta, Georgia. Before COVID, Lisa was a frequent speaker on estate planning topics. Lisa is a member of the East Tennessee Lawyers Association for Women, Knoxville Area Estate Planning Council, the Tennessee Bar Association, and the Knoxville Bar Association, and has played an active role in numerous civic and charitable organizations. Lisa, we are thrilled to have you here. What a great topic today, and I'm going to turn over the time to you.
Well, great. Thanks so much for having me. What I'm going to talk about today is really a topic that every estate planning attorney wishes their clients knew more about. And that is what really happens after someone dies. I don't mean in an afterlife sense. I mean, what happens to someone's assets after someone dies? Because if you've watched a lot of Hollywood movies, you probably think you know what happens. You probably think the first thing that happens is the family gathers at the lawyer's office. Everybody's very nicely dressed, except for the one rogue grandchild with the purple hair and the heart of gold. The lawyer looks like George Clooney. There's a lot of dark wood paneling on the walls. And then what happens? The reading of the will. Well, no, that's actually not what happens. As a matter of fact, that almost never happens anymore. Sometimes there's the mailing of the will, but even that isn't the first thing that happens with an estate. The first thing that happens after someone passes away is actually much more mundane. What we ask the family to do is make a list. Okay. And this list needs to cover everything that the decedent owned or controlled in any way. When I asked for this list, one of the most important pieces of information the family thinks they can give me is the value of the asset. And actually, that's not what I'm most interested in. What I really want to know about on this list, the most important thing is, first and foremost, how was that asset titled? Was it titled just in the deceased person's name alone? Was it joint with someone else? This requires a great deal of precision. People think they know how they own their assets, and they are often wrong. So sometimes it's a really good idea to go back and look at the original source documents. How does that deed actually read? How was that card actually filled out at the bank? How was that agreement actually filled out with the financial advisor? So how things are titled are hugely important. The next thing I want to know on that list of assets is, did the decedent name a beneficiary for that particular asset? Did they fill out some sort of a beneficiary form? And if they did, who was named as that primary beneficiary? And I also want to know who was named as the contingent beneficiary. So those are all vitally important things to put down. Do I also want to know how much the asset was worth? Well, yes, that's helpful, and it's going to become important as we move along. But of these things at the beginning, it's actually the least of the three important of the three things. The second thing that we do after someone has died, once we've made this list, is that I then need the family or the survivors to understand that assets pass in 4 different ways. So if you want to figure out who gets what, we don't start by looking at the will. We start by looking at this list. And we put this list through an analysis, because sometimes assets pass because the asset was titled with a survivorship feature. That's one way they might pass. Another way they might pass is because the deceased filled out a beneficiary form that specified where it went. Sometimes the asset is owned by or payable to a trust. If that's the case, then I'm interested in what that trust says. And finally, just one of the 4 ways the asset might pass is that person's will. So the will's not the only thing that's going to be determinative here. It's just one of 4 ways. So let's talk a little bit about some of these different ways. The first way that assets sometimes pass is because they are survivorship assets. So this is a situation where the asset itself tells me where it's going to go. If you want the fancy legal term for that, we lawyers say that these assets pass by operation of law. And there are a couple of different types of survivorship assets. The one that you're probably most familiar with, that almost everyone has been a party to at one point or another, is an account that's titled in joint tenancy with right of survivorship. Sometimes you'll see this abbreviated as JTWROS. That may even appear right on the bank or brokerage statement. But if it doesn't necessarily mean you don't own the account that way. It's just that every financial institution designs their forms however they want. This can be between two people or more than two people. When the first owner dies, the asset automatically passes to the surviving joint owner or owners. Do we care what the will of the deceased owner says? Not at all. We don't care about it. We don't care if they have one. If they have one, I don't even need to get it out of the drawer to see where this particular type of asset goes. The asset itself is telling me where it goes. Another really common type of survivorship asset, particularly here in Tennessee, is something that's called tenancy by the entirety. Okay, now this is only available to married couples. Tennessee has it, actually several other states, Florida is one, but it's not universal. It's most often something we see on deeds. So if you're married and you go take a look at the deed to your house, it may not have your and your spouse's name as joint with right of survivorship. It may say something like Bob Doe and Jane Doe, husband and wife. It can also say Bob and wife Jane, Jane and husband Bob. It might even use the Latin terms for these words. So et ux stands for and wife, and et ver stands for and husband. But any combination of these words is a sign that you're intending to own this particular asset as tenants by the entirety. So tenants by the entirety has the exact same survivorship feature that joint with right of survivorship does. When the first spouse dies, it automatically passes to the surviving spouse. I don't care if the first spouse had a will, and if he or she did, I don't care what it says. This asset passes by operation of law. Sometimes I have surviving spouses who get really nervous because there's no deed that takes the piece of property out of the name with their deceased spouse and put it just in their name. And no deed is necessary. Because this happens by operation of law, as long as the couple never divorced, it's automatically the surviving spouses. And the document that replaces the deed in that chain of title is actually the deceased spouse's death certificate.
Very interesting. I think Alex had a question he wanted to address. Go ahead, Alex.
Yeah, I got two in here. I don't know which exactly list they're talking about with this one question, but I'm going to assume it's survivorship assets. Can you give examples of what sort of assets are included in that? More than a joint account. We're all familiar with that. Is there any other examples other than a deed as well?
No, the most common things are to have a bank account that's titled joint with right of survivorship, to have a brokerage account that's titled joint with right of survivorship, or to have a piece of property that is titled either joint with right of survivorship or tenancy by the entirety. Those are the three main asset categories that we see for this, but that covers a lot of territory.
Yeah.
Lisa, can I ask a follow-up question before Alex goes on there? So step one was obviously in making the list, and I do get this question from clients a lot. Is that literally everything? I mean, how do you go about and when do you stop?
Okay, so it's absolutely everything with a title. So cars, boats, all of those things. Does it include personal effects? Normally, when we're talking about this, I treat personal effects as a category. So if the family came in and there was just a line that said personal effects, that's fine. So mostly things with titles. But what I will say are small assets count. And in some ways, and we're going to talk about this later, they matter more than large assets in certain ways because they're more annoying to deal with if you forget to tell me about them. So a $600 bank account is something I need to know as much about as a $6,000 or a $600,000 bank account. Every asset counts.
Go ahead.
Okay, so let's talk a little bit about some of the things I wish my clients knew about survivorship assets. And boy, people think they know everything there is to know about JTW ROS assets because we've all had them. Some people have had them for decades with their spouse. But there's actually a lot to know about them. They are the #1 source, certainly in my practice, of litigation or potential litigation or disgruntled children. These accounts cause lots and lots of strife in families because I don't think clients understand them well enough. So the way these accounts typically come about, it's not unusual. Husband dies, everything passes to wife. A lot of the bank accounts were joint with right of survivorship. And then wife decides she's going to go move by middle daughter over to North Carolina. And they go to the bank together to open up mom's new bank accounts. And the lady at the bank sits mom down and says, I see you're here with your daughter today. You know, you should put your daughter's name on your account so she can pay your bills if you get sick, and it'll avoid probate. And if you're sitting there at the bank, you're going to think that sounds like a fabulous idea. And after all, the lady at the bank recommended it, so it must be a good idea, right? Well, a lot of the times it's not a good idea. People who do what I do have a couple of things we wish that lady at the bank would tell you before you decide about this. The first thing I wish they would tell you is, well, you're not putting your daughter's name on your account. You're making your account your daughter's as much as yours. It doesn't stay your account. After you do this, it is both of your accounts. You each have an equal interest in the money. You've made her your equal. And if she wants to take every penny out and hightail it to Acapulco, she's perfectly legally entitled to do that. Now, most people aren't too worried about that. They trust their children on that case. But the next thing I wish the lady at the bank would say is, because this money's as much your daughter's as it is yours, if she has any creditors, if she's at fault in a car accident, if her 16-year-old son's at fault in a car accident, if she has any back taxes, alimony, child support due, well, this is her money and it may be subject to her creditors, okay? Or if she gets a divorce, you should expect there to be subpoenas of your records relating to this account because it's just as much her money as it is your money. You've opened up your account and exposed it to all of these things by making somebody your co-equal. Once you put your daughter on there, you can't get her name off without her consent. Why? Because again, it's not your money anymore. It belongs to both of you. But the biggest thing I wish the lady at the bank would tell my client when they're making this recommendation is, you know what? And when you die, this account will pass solely to this one daughter whose name is on it. It will not pass under your will to all of your beneficiaries equally. And guess what? That daughter will be under no obligation to use that money to pay your funeral or any of the other things you think that she's going to pay with that account. She gets to keep the whole thing as a bonus on top of her equal share of your estate that passes under your will. You know, when most clients find out that that's what joint with right of survivorship actually means, it suddenly doesn't look so good anymore. Now, I do have clients who say, well, you know, if this $60,000, $70,000, $100,000 money market account goes just to this one daughter, I know she'll do the right thing. Well, I will tell you from my personal experience in my practice, talking to some of my other colleagues around town, maybe 20% of the time. But it's really hard because how does she know what the right thing is? You set it up to go to her. Who wants to overrule their parent? No, mom did it wrong. So most of the time, these accounts have an unintended consequence of disinheriting the children who are not on the account with the one who was. And this causes so much in the way of hard feelings. It tears families apart. Sometimes we intend for this to happen, not tear families apart, but sometimes we really do want an account to go to someone. And there's some ways and some things that your estate attorney can recommend to do that will lessen the strife amongst family. Because the big thing is people think mom got talked into this, mom got coerced into this, mom didn't understand this, and that's why she did it. So diffusing some of those alternative scenarios are important to that. But it's very important that clients understand how these survivorship assets work, because they're a bit of a different animal when you are doing it with your child than when you had it this way, perhaps with your spouse. There's a couple of things I like everybody to know about tenancy by the entirety assets as well. This is the marital form of ownership. The first thing to know is that if you own a piece of property this way and then you get divorced, the divorce breaks the tenancy by the entirety and now you co-own it, but there's no survivorship feature. If the two of you get remarried, which happens way more often than I would have ever suspected, it does not reattach. You actually have to change the deed if you want to get it back with a survivorship feature to it. There's also a couple of things, especially my retiree clients should really be aware of with this tenants by the entirety. I have a lot of clients where the wife is keeping the name that she's had for 30, 40, 50 years. So the married couple is going to have different names. In that case, a lot of times the title companies do not title it as husband and wife. They may not even be aware these two people are married. And if it's not titled as husband and wife, do you own it as tenants by the entirety? That's not clear. And those are words you never want to hear an attorney say. So making sure about that. The other thing that I sometimes see with my retiree clients is that you're getting married, you're going to share names, and you tell the title company to put it as husband and wife, and you buy the house a week before you get married. That doesn't work either. You actually have to be married on the day you're trying to create this tenancy by the entireties. So it's important to know those things. Let's talk for a minute about a third form of co-ownership, okay? And this is one that's called tenants in common, and it doesn't have a survivorship feature. So this is where two people buy something together, or, really commonly what happens is people inherit property, siblings inherit property from their mom or from their dad, from their parents. So this is the way you'd own a piece of property with a brother or a sister if you inherited it. If I die, does my share go to my two brothers? No, it does not. There's no survivorship feature. My share would go to my children or however my will says. So that's what tenants in common does. There's no survivorship feature. Now, a lot of people think, well, I don't own anything as tenants in common. And that may not be true. As you heard in my bio, I've been doing this for a long time. And when I started practicing in this area of law, the estate tax exemption, that is the amount that somebody could leave to their children before there was a federal or at that time a Tennessee inheritance tax, was $600,000. And that number's been all over the place. It's been $1 million, $2 million, $3 million. Currently, it's $12.06 million. But back when it was $600,000 and lower amounts, lots of people had estate tax planning done. And that kind of had a couple components to it. It meant that you got wills that created trusts to try to avoid or minimize the estate tax. And as part of that process, lawyers like me told our clients, we don't want you to own your property as JTWROS. We don't want you to own your property as tenants by the entirety. For tax planning purposes, we really want you to, and the term we used was asset splitting. We wanted some assets over in the husband's name and some assets over in the wife's name. And one of the ways we did that was to change a bank account or a brokerage account or a piece of property into tenants in common. Because both spouses' names still appear on it, you may think that that account is joint with right of survivorship when it's really tenants in common. So just because both names are on it doesn't mean it's joint with right of survivorship. Lots of clients who had these tenants in common accounts may not need them anymore. So if you still have them, this is a good time to go talk to your estate planning attorney or your financial advisor about whether that's the best way to have this account titled. So that's due to recent changes in the tax laws. So that's assets that pass by operation of law or a survivorship feature. The will doesn't matter. The next category of assets I want to talk about are beneficiary assets. So this is where the deceased owner actually filled out some type of a form with a third-party financial institution. It could be a bank, it could be a brokerage, it could be their employers as to their 401k plan. We lawyers say that these assets pass by contract. You're probably thinking, well, I didn't sign any contract, but yeah, you kind of did. When you set up that bank account, when you opened that brokerage account, if you're party to a 401k plan, there's an agreement that governs that account. And when you fill out these forms, that's part of that agreement. We have different names for these forms. They kind of come in three flavors. When we're talking about forms for IRAs or 401ks or for life insurance, they're pretty commonly called designation of beneficiary forms. If you're talking about an investment account that's not an IRA, you might hear the term TOD, which stands for transfer on death form. That's a real common terminology. Banks have the exact same concept, but for some reason they call theirs POD forms, which are pay on death forms. So those are the typical type of beneficiary forms you might have. If you have filled out a beneficiary form, that's going to tell us where that asset goes. I am not interested at all in what the will says. So it's always important. People always want to know what overrides what. Well, the form's going to override your will. There are a couple of exceptions to that. Sometimes the form will say that the estate is the beneficiary. If a form says that the estate is a beneficiary, that's kind of code for go read my will. So in that case, the will matter. Sometimes a form fails. Okay, what I mean by that is that either you didn't name a beneficiary on the form or the beneficiary you named died before you. What happens then? Does it go to your estate then? And the answer to that is, I don't know. What does the contract say? So now we're back to why the contract matters, because every one of these companies, these financial forms has its own default, and the default may not be what you think. Sometimes the default says, oh, if you don't have a beneficiary, if you forgot to name a beneficiary, it'll get paid to your spouse. And if not your spouse, then to your children. And if not to your children, then to your estate. Some other companies do it differently. They say the first default is your spouse and the second default is your estate. This can really, really matter, especially if you have done important things with your will. For example, I have some clients who have children with drug problems, and we're not leaving them money. We're maybe setting up money in trust for the grandchildren. Well, if you didn't name a beneficiary for your life insurance or for your IRA, and that default form says the default beneficiary isn't your estate, it's your children, they may pay that money out to that drug addicted child directly. So knowing what your beneficiary forms say, making sure your beneficiary forms are up to date, and naming both primary and contingent beneficiaries is really important. This is one of the ways in which having a really good financial advisor is a huge help, because financial advisors generally work with their clients. Maybe they even annoy you a little bit by pushing you to make sure that you have done these things for the assets you should do them for. You know, your online downloaded form's not going to do that to you. Beneficiary assets, they follow the beneficiary form. The will doesn't matter. Like
Lisa,
everything. Yeah.
I did have a question, actually.
Sure.
That's perfect timing. Well, the question that came in was, how often are beneficiary forms not filled out? How often do you see that?
I would say probably in the estates we handle, about 1 out of 4 to 5 has some beneficiary form that has failed in some way. And it's really typical to come across something where the wife was named as the primary beneficiary and she predeceases the husband and there's no contingent beneficiary at all.
Yeah.
Stuff like that.
How often should they be reviewed? Our service model here, we review them annually.
I think annually is an outstanding idea. Really, if I had my druthers, I would say that on a more realistic basis, if you get routine fiscal checkups with somebody, every 4 to 5 years, or more importantly, when something dramatic happens. So if somebody dies out of order, if you lose a child, if somebody develops a drug problem, if there's a divorce, big family changes ought to spur you to think about these things, okay? Because estate planning is the intersection of the two things that matter to us most. Family number 1, but money number 2. Or maybe not the most, but anyway, it's the intersection of these two things. And so changes in either of those sort of environments ought to cause you to rethink your estate plan and just double check and make sure that all your beneficiary designations are the way that you want them. There's definitely several things to know about naming beneficiaries on these beneficiary forms. In my opinion, there's a whole art to it. But the most important thing I'd like clients to think about when they're filling out these forms is what happens if someone dies out of order? I mean, if you come see me or your estate planning attorney, you're going to get asked the question all the time, what if this person doesn't survive you? What's happening to this asset? And that's something that when you're filling out these forms, you need to be thinking about. What if this person doesn't survive me? So let's look at a really typical example. Jane is a surviving spouse. She has this large IRA. She received her husband's IRA. She rolled it into hers, and now she's naming beneficiaries for it. And she's going to name 34% to her daughter, Beth, and 33% to her daughter, Sue, and 33% to her son, James. So what do you think happens to Beth's share if Beth doesn't survive Jane? Well, there's a couple of possibilities. The most common one is that if there's nothing else on that form, it's going to be likely that the contract or the form somewhere in it says, if one of the beneficiaries doesn't survive, but you have other beneficiaries who do, well, we're just going to give it to the beneficiaries who survived you. So in this scenario, Beth's share would go to her sister Sue and her brother James. They would split the account 50-50. So who are we disinheriting here? We're disinheriting Beth's kids, the grandkids. That happens more often than you might think, and it's always an unfortunate family event when it does, because no one knows if that's what grandma really intended. And sometimes people will say, well, what about Jane's will? I mean, look at that as an example. In Jane's will, anything that was supposed to go to Beth, if Beth didn't survive her, was to go to Beth's kids. Shouldn't that influence what happens here? And the answer to that is no. I mean, maybe it should, but it's not going to. Why? Because the will doesn't matter. This asset passed by contract, by beneficiary form. That's what's going to govern. There is another possibility for how this could go. And this is if Jane had filled her form out so that it went to 34% her daughter Beth per Stirpes. If there's one thing I can hope you take away from today's webinar, one legal Latin term I want you to learn, it is per Stirpes, and it is Latin for by the branch. If you have filled out your beneficiary form so that it goes to your beneficiaries per Stirpes, then if Beth doesn't survive Jane, where does Beth's share go? It does go to her children. That's what the per Stirpes means. It goes down that branch. Now, people will ask me, well, does that include her husband? Because we don't actually like her husband all that much. And the answer to that is no. Down the branch means her children, her grandchildren, her great-grandchildren. Does not include stepchildren. It would include adopted children because adopted children are children. But that's what the per Stirpes means. And then the client will ask, well, we hope that Beth is going to have children, but what if she doesn't? Will it go to her husband then? And the answer is no. It will go. If that fails and Beth didn't have children at all, it would in fact wind up going to Sue and James. It would rotate down that way. So again, per Stirpes does not include husbands. It does not include stepchildren. But it is a very important legal concept to understand. And people have filled out these beneficiary forms all their lives, sometimes for assets worth millions of dollars, and they have never really thought very hard about this concept at all. So that is something to think about. And to go back to your question, Alex, the birth of grandchildren, great time to spur the thinking, because maybe when you filled this form out, your kids weren't married and hadn't children yet, and this wasn't even on your radar, the whole concept of grandchildren. So another thing that I'd like people to know about beneficiary designation assets is this common scenario. I've got a client, we'll call him Bob. His first wife, Jane, died. They had two lovely daughters, Cassie and Anna. Bob's got a great relationship with his daughters, loves them dearly. He meets Cindy, great woman. They get married. She's a widow with two children of her own. We're all very happy that these two people have found each other and now have new partners. And Bob has filled out his IRA beneficiary form, and this may be his largest asset. And he has said that the primary beneficiary is his wife, Cindy, and the contingent beneficiaries are 50% his daughter, Cassie, per Stirpes. He gets an A+ for that. 50% his daughter, Anna, per Stirpes. And then Bob comes to see me and I say, Bob, how have you named beneficiaries for your IRA? And he says, well, my IRA goes first to Cindy and then to my girls. Is Bob correct? The answer to that is no. No, Bob is not correct. Beneficiary forms get read one time when the account owner dies. So in this particular case, Bob's IRA is going to go either to Cindy if she survives him, or to his girls if Cindy doesn't survive him, but there's no sequential thing going on here. So if Cindy survives Bob, they read that beneficiary form, beneficiary is Cindy, she's living, let's give the IRA to Cindy, and then they take that beneficiary form and they crumple it up in a ball and throw it away. It's done. It's done everything it's going to do. I mean, figuratively, they throw it away. I don't know what they really do with it, but it has spoken, it's one time, it's not going to control what happens to it when Cindy later dies. So what is going to happen to it when Cindy later dies? Well, it depends on what Cindy chooses to do. A really common scenario is that the IRA will have been rolled over into Cindy's own IRA, and she's now sitting there with one big combined IRA, and she's got a beneficiary form she filled out a long time ago. And what does her beneficiary form say? It says her children, understandably. So when Cindy dies, it will go to her children, and Cassie and Anna are not going to get anything from the leftover portion of their dad's IRA. That's a real common scenario. Cindy doesn't have to roll it over into her own IRA. She could open a new IRA and roll it over to that. But again, she's going to be asked to name beneficiaries, and she's a mom. And what's she going to do? She's going to name her kids as the beneficiaries of her, what is now her IRA. So it's important to understand how these beneficiary forms work. It's not first this beneficiary, then this beneficiary. It is my primary if they're living, and then we're done. If they're not living, then it'll go to the contingent beneficiary. That is overwhelmingly how those forms work, and it's important that folks know that. And again,
Lisa,
yeah.
I'm so sorry. We have a couple questions, and I interrupted you. Alex has a question, but I have it just as you talk, and I think about most clients having a lot of their assets as they're saving going to 401ks and eventually IRAs. I mean, is this the common misstep? Because I can think of a number of situations of what you just described that were caught. Is this what you typically see as the number one misstep that's out there, or at least in the top few?
Yes, in blended families. I mean, there are enormous numbers of children who wind up being disinherited, where I'm not at all sure that was intended. And that's because blended family planning is tricky. Blended families are special, but it can be done. And we have a lot of estate planners. We have a lot of tools in our box to talk to you about the different ways to address these issues. But people are reluctant to go there, and they just set things up, and they really don't think about how it works or how that second step is going to work.
I have two here. I think the first one's, from what I'm hearing from you, is it's a no, but can beneficiary forms expire?
Not that I'm aware of, no.
Okay. And then can you talk a little bit about naming minor children as beneficiaries? How does that work?
Yeah, so that's always a very hot mess. Technical legal term there. You certainly can name minor children as beneficiaries. That requires their guardian to actually go get a public guardianship over them, apply for that benefit, and monitor and take that benefit and spend it in accordance with the law. So it's like any other time that you have something going to minor children. Minor children can't inherit directly. They can't be parties to contracts. They can't own these types of assets. So there is a legal process called guardianship that has to be imposed to make that happen. You can, what I prefer to see, and it's not always practical depending upon the size of the account, what I prefer to see, if we know IRAs and 401ks or other assets are going to go to children, is setting up a special type of trust designed to own IRAs. That sometimes they're called, this is beyond today's scope, but accumulation trust or IRA conduit trust, some type of an IRA see-through trust that's specifically designed to hold those types of benefits for a minor child. So that's usually what we like to see. If you remarry and you have an not an IRA, but you have a 401k or a profit sharing plan that is governed by ERISA, which most 401k and profit sharing plans are. IRAs are not. Your spouse may have rights no matter what that IRA beneficiary form says. So if you have a 401k and it names your children and you remarry and you do not get a prenuptial agreement, that spouse may be entitled to that entire 401k plan, unless they have waived their rights to that. Now, those ERISA rules don't apply to IRAs, and so sometimes in those situations, you may want to talk to your financial advisor about moving money out of the 401k or profit sharing plan, if you can, over to an IRA where you have more flexibility about naming beneficiaries. Although, of course, as an estate planning attorney, if you're contemplating remarriage, I'm always going to recommend that you get a prenuptial agreement so some of these things can be ironed out. So the third way assets can pass, so let's remember, by operation of law, that's our survivorship assets. By contract, that's our designation of beneficiary assets. A third way is that they might pass by trust or a trust agreement. So sometimes you'll see, lots of people like to read the newspaper about who buys and sells properties. You'll see people taking title to property. Susan Smith, trustee of the Susan Smith Revocable Living Trust. If Susan dies, do I care what Susan's will says? I think we're maybe a slide ahead, but do I care what Susan's will says? No, I do not. Her will's not going to control where that asset goes. The Susan Smith Revocable Living Trust is. Same thing, maybe a trust is a beneficiary of an asset. So let's imagine that our couple, Bob and Jane Smith, own a bank account, joint with right of survivorship, but they've made it TOD, transfer on death, to the Smith Family Joint Revocable Living Trust. How's that going to work? Well, when Bob dies, it's going to go right to Jane, right? By operation of law, JTWROS, very first thing we learned today. Does Bob's will matter? No, it does not. What happens when Jane later dies? Well, because the account is TOD to a trust, I don't care what Jane's will says. I care very much what the trust says. So we're going to go find that trust and read it, and it's going to tell us what happens to that account. But I don't need to read Jane's will. So when assets pass by trust, again, they're not passing by the will. This brings us to our last category. Finally, the will. Sometimes we call these the probate assets. So what if none of the above apply? What if you have an account or an asset that's not a survivorship asset where there's a surviving joint owner? What if there's no beneficiary named for it? What if it's not owned by or payable to a trust? What happens to it? I don't know. What did their will say? That's the question you'd ask, right? What did the will say? So finally, the will matters. Finally, the will is going to tell us what happens, but only as to assets in this category. It's still not going to go back and override any of the stuff we've already talked about. What if you don't have a will? Well, no worries. Tennessee's written your will for you. It's called the intestacy statute. And if you live in another state, well, your state has an intestacy statute as well. So all people die either testate, which means with a will, or intestate, which means without a will, or last will and testament. That's where the word testate comes from, the testament part of this. So what you should know about dying intestate. The first thing to know is that you have an administrator, not an executor, but they will probably have to post a bond and file detailed inventory with the court and file detailed accountings with the court. Why? In most of the times when there's a will, we waive all that stuff. It makes the administration of an estate so much easier and quicker, but you can't do that if you die intestate. Also, you don't know what the intestacy statute does. I mean, you basically let Tennessee write your will for you. So let's talk a little bit about what that will might say. If you are married with children, guess what? It doesn't leave it all to your spouse. No, your spouse and your children will split those probate assets equally, but a spouse never gets less than a third. So if you only have one child, your spouse will get half and your child will get half. If you have two children, everybody gets a third. If you have 6 children, your wife will get the third, and the other 6 children will split the other 2/3. So that's kind of how that works. If you are married with no children or no children in common, you're going to get some very strange results depending upon the order in which the spouses die as to these probate assets. let's think about, and this is a terrible job I have, a situation where there's a car accident, right? Husband dies day 1, wife dies day 7. What happens? Well, for their assets, okay, a whole bunch are going to go from husband to wife, and then from wife, they're going to go to wife's family. Okay. Now, what if we switch the order of deaths? What if it was wife that died day 1 and husband died day 7? Well, then the same group of assets is all going to wind up with husband's family. Completely random, depending upon the order of the deaths of these two people. Again, this tears families apart. Nobody's certain that it was intended to work this way. It wasn't intended to work this way. It's just nobody thought very hard about it. So I always like to tell clients, you have an estate plan, whether you know it or not. You just may not know what it says and what it's going to do. But there are a couple things I like folks to know about probate. You know, there's a really common phrase that we all say. I hear it all the time. I even say it. Did you have to probate your grandma's estate? It's not technically correct. You know, the estate is the whole enchilada. It's everything you own. It's the stuff that passes by survivorship. It's the stuff that passes by beneficiary form. It's the stuff in most trusts and the stuff that passes under the will. So your estate is really the whole enchilada, and that's not what you're probating. The thing you're probating is the will. That's what the word probate means. It means to prove the will, the authenticity of the will. So that's what happens. So if every asset on that list, and we are back to that list because that list governs this whole process, if every asset on that list passes in one of the first 3 ways, it's a survivorship, or there's a beneficiary designated, or it's in some kind of a trust, and there's not a single asset in that 4th category, then we don't need to read the will because it doesn't do anything. And if we don't need to read the will, then we don't need to probate the will. And probate is completely unnecessary. But if there's even one asset in that 4th category, then we need to do the same probate more or less we might be doing if there were 15 assets in that 4th category. And so when I talked to you earlier about why small assets matter a lot, this is why they matter. So, you know, imagine a married couple and they've got 12, 13, 14 assets, and husband dies, and 13 of those assets pass to wife because they were joint or she was the beneficiary. But oops, he's got this one account that was in his name alone. He never made it joint with her. He never put her as beneficiary on it. Well, if that's $1 million brokerage account, and I tell wife, sorry, you've got to probate his estate to get that account, she's not going to be happy, but it's okay, we've got to do what we've got to do. If that account is $2,000 in a bank account where he kept his consulting income and he never made it joint with her and he never made it payable on death to her, and I tell her she's got to do a probate to get a $2,000 bank account, that is an upsetting thing to have to tell somebody. The fact that that account was so small has caused outsized problems. Would I have much rather he had a conversation like the one we're having today and he'd gone and put in her joint on that account, or even just made it POD to her? Yeah, that would have solved the problem. So how you title assets matters a lot, and it will determine whether probate is necessary or not. So there are a couple of other things to know about probate. In Tennessee, we actually have a couple of different kinds of probate. Full probate comes actually in 2 flavors. We call it common form and solemn form. Almost nobody ever does solemn form, so we don't. Common form is what the probate you've heard about. There's also a small estate affidavit procedure, and that's for estates of less than $50,000. There's recently been a change in the law, guys, just in July, where that is available only for intestate estates. It's not available where there's a will any longer. So that's a real recent change to Tennessee law. One of the things I find the most useful is our probate as a muniment of title procedure. This can be used for all sizes of estates, and it's particularly helpful for real estate. And it's kind of just where it's a very simple form of probate where we just record the will almost as if it was a deed, and then we're done. So there's times where that's an appropriate form of probate. So all forms of probate aren't the same. It's important to know that in Tennessee, probate is cheap, easy, quick, and simple. And it's not based on the size of the estate. I can't tell you how many clients who say, oh, you know, I've got this $1 million account. I better put some beneficiaries on it because if it goes through probate, it's going to cost a fortune. No, not necessarily. At least the probate court costs are not in any way related to the size of the account. That's not true for all states, by the way. A couple other things. If somebody owns real estate in another state, then probate, not just in Tennessee, but probate in that other state might be necessary if this is one of those Category 4 assets. And that's because South Carolina, when it comes to South Carolina real estate, doesn't care much what a Tennessee court has said. They want to prove the will themselves and issue their own papers. So we call that ancillary probate. So you probate in the home state and you probate in the ancillary estate, and it's only real estate that triggers that. Another important thing to know about probate is that it is public. So once you have recorded the will, once you've offered it for probate, anybody can get a copy. I always like to tell people, if you want to pay $10 to Shelby County, you can get a copy of Elvis Presley's will. It is a public document. Sometimes that's not a great idea. You know, I've got trusts where, again, because of divorces, because of addictions, we're doing things for children or grandchildren that we don't want to be public information. And in those cases, talking to your estate attorney, telling them that privacy is important for you, we can talk to you about some of the options that are available to give you more privacy. But generally, when we are talking about your estate, how your estate will pass, who gets what, whether there's going to be fights, often is determined by, this is your takeaway from today, 4 things: how assets are titled, how you've named beneficiaries, whether that asset is owned by or payable to a trust, and what your will says, as well as how all of these things work together. And I find that this is a particularly important conversation to have with my clients who are retired. Why? Because once you retire, you have plenty of time to start thinking about these things, and you start talking about these things on the pickleball court or on the golf course, and you're going to hear people make recommendations. Oh, I put all my kids on my accounts for this, that, or the other reason. Are they mentioning the per stirpes thing? Did they tell you about that? Maybe not. So it's really important. What we see is in that retirement phase, we see people making lots of mistakes when it comes to titling assets and naming beneficiaries, and taking advice from all kinds of random sources. So a methodical approach, understanding how assets pass, consulting with your financial advisors. I mean, there's a reason that a good financial advisor takes a holistic approach. They aren't concerned with just your account. They want to talk to you about how your account is titled, how you've named beneficiaries. If you don't have wills and powers of attorney and things like that in place, they're probably going to nag you to come see somebody like me. And it usually means because they have your best interests at heart, because that's what they should be doing, making sure that this whole package is done. Because when it's done well, this cuts down on those lawsuits between siblings, intrafamily fights between siblings, the ill will that arises when things have been left in one way and the other kids aren't sure that's what mom intended. So that's my big takeaway. I try to make sure all of my clients understand how important all 4 categories are and how all 4 categories work together.
Wow.
So,
Lisa, I'm so excited to have you presented. What an interesting and very informative presentation. Corey and Alex, I know we have some questions.
We do.
We might need to pick and choose just so that we can end on time. I don't mind if it's okay with you, Lisa, if I'll keep you for a couple more minutes. I know we had more questions than we could probably answer in 5 minutes. But I'll go ahead and turn the time over to our moderators.
Yeah, we'll be respectful of time. So classic question, given how few assets get down to the bottom of no beneficiary, not jointly owned, can I handwrite my will? Is that okay? I get that all the time.
So it's legal. You probably don't know the requirements though to make it legal, and you're probably going to ruin it. And cause more trouble than it solves. So, yeah.
All right, Alex, you want to ask the next couple?
Yes. First one, what is a better way to handle having an adult child to be able to access a parent's account, like help paying bills instead of making them a joint owner of the account?
So many banks will offer what is called an additional authorized signer. So this is somebody, I want to be able to write checks on my account, make deposits to my account, but it's my money, not theirs. If I die, it doesn't go to them. Their lawsuits and creditors can't get it. So that's called an additional authorized signer.
Gotcha. Great.
Virtually
Second
every
one.
bank offers it.
Yeah, this second one's already been answered. You know, how to avoid disinheriting children and grandchildren. You talked about all the PERS and so on and so forth. So I'll move on. Corey, you want to take the last three?
Yeah, talk about debts in the estate, obviously, whether it be short-term rolling cards or the phone bill or bigger debts like a mortgage. How do we handle that? Student loan, those type things.
Well, so generally speaking, debts are paid out of the fourth category of assets. Sometimes if there isn't anything in the fourth category, but there are trust assets, those trust assets can be reached for them as well. If there are no assets in either of those, sometimes those debts will go away. We also have to make creditors file claims. So when we probate a will or an estate and send that creditor a notice, if that credit card company doesn't file a claim with all the bells and whistles and the attachments they're supposed to, which they almost never do, then that claim is disallowed. But there are some responsibilities under Tennessee law. For example, spouses are responsible for other spouses' medical bills. So if there isn't enough to pay in the probate estate to pay your spouse's medical bills, the medical provider can come after you under something called the doctrine of necessities. So you are liable for providing your spouse's necessities.
Got it. To wrap up, and again, I know we're up against it, but someone's gonna come and talk to an attorney. What are the first steps before doing so? What's the first thing? Is it that list you talked about, or if they're convinced to come talk to someone, what do they need to do right now?
Really, so the biggest thing they need to do is that list, and then they need to be willing to come and talk to the attorney honestly about, do I have a blended family situation? Should I be seeing an attorney on my own and maybe not with my new spouse? Can I honestly tell my attorney about my child out of wedlock that I'm estranged from, or my child who has a drug or addiction problem, so that the attorney can solve it? The thing that keeps people from coming to see me is when they finally talk to me is they don't know what to tell me they want. And I always say, that's not your job. I'm not a scrivener. Your job is to tell me the problem, and my job is to give you the solutions. It's a little bit like not going to a doctor because you don't know what disease to tell them you have. Go and share the symptoms and let the doctor tell you. So come see your estate planning attorney. Tell me about your assets. Tell me about your family, and then your estate planner, we'll work with you to tell you the tools that we have that you may not even be aware of, whether it's trusts or other vehicles, in order to do what it is you're trying to achieve.
Well, folks, that's about all the time we have today. I want to thank both our moderators. Thank you, Corey and Alex, for the great moderation. I want to thank Lisa for just such an informative, information-rich webinar. We appreciate that and want to thank the organizations for making this webinar possible today. Look for an email soon with a link to the replay of this event, and you're welcome to share that replay with friends and family. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much, everyone, for coming, and we'll see you at another webinar soon. Bye, everyone.